Tonight we are going to discuss Davis versus the Monroe County Board of Education. This is a Title IX case, but I think you'll find that this is a little bit different from what most of us think about when we think about Title IX. Now, before we get into some more details regarding this case, what I'd like to do is find out what you all believe Title IX to be. So for the next couple of minutes, we're going to take some time and have each of you partner up with someone in your area, and I would like you to discuss what you believe Title IX to be. I think we can all agree after listening to the comments from other students that most of us believe that Title IX is basically referring to sports. And I think that's how most of us were educated as we went through school and talked about what Title IX meant to us. So what does that mean? That means that most of us think of Title IX as something that happens on campuses in regards to sports equity. Do each college campus and high school campus have enough activities for girls as they do for boys? Is there enough money going into the girls program compared to the boys program? Do we have the same kind of benefits regarding the girls programs and the boys programs? And these are the kinds of things that most of us are familiar with when it comes to Title IX. The main reason I chose this case to present to the class this evening is because my view of Title IX has always been the same as what we discussed earlier. Mostly sports, mostly is there enough for girls versus boys, those kinds of ideas. This specific case, Davis versus the Monroe School Board, is different because A, it has nothing to do with sports, and B, it has to do with young kids, and that kind of drew my attention to this case. All right, so let's get to the facts. There's the petitioner, who we can only assume is the mother of the alleged victim. I say assumed because they never really state whether it's the girl's mother or not. And then we have the school board at the Monroe County in Georgia, and we also have the school principal, who is one of the defendants as well. And what happened in this case is that we have a 5th grade girl whose name is LaShonda, and she is being sexually harassed by another student in her class. This student is known as GF. The first alleged incident in this case happened in December of 1992. It was at that point that LaShonda said GF made vulgar remarks to her, things like, "I want to be in bed with you," and he was attempting to touch her breasts and her genitals. It's unclear whether LaShonda reported the first incident of sexual harassment, but it is clear that she did report 2 other times in January when it happened again. Now, she reported this to the petitioner as well as to her classroom teacher. The petitioner, being concerned, contacted the classroom teacher, and the teacher assured her that this was being reported to the principal, Mr. Query. If you know nothing about this case, I think most of you would be surprised to find that this harassment did not stop until mid-May. So this 5th grade student was being sexually harassed on a consistent basis from December through May. At this time, what I'd like to do is take a little time for us to think about how we would have handled this had we been the administrator in this position. Without knowing anything else from the case, let's discuss some of the options that might have been available to us. I think that one of the clear topics that came out of our discussion was the fact that as a parent in this situation, really what you're looking for is for the situation to be rectified. You're not looking to get paid. You're not looking for things to happen in regards to capital type punishments. What we're looking for is a change. And I think that's what was missing for the most part from this case, and that is why the petitioner brought forth what she did. Now, as we delve further into some of the facts of this case, we find that there were other victims of this particular student, and that the girls got together and tried to discuss with the principal what had been happening. Unfortunately, when LaShonda addressed this with her classroom teacher, she was denied the opportunity to go see the principal, stating that if he wanted to see them, that he would call them down. So she didn't get the opportunity to actually speak to the principal himself. And I find that odd. I find that as a school principal or a classroom teacher, you would try to do everything you can to protect this student from the harassment that they're claiming. So what changed in mid-May that brought the end to this harassment? As we look into this case, it tells us that the student known as GF, he did admit to sexual harassment, and he was charged and pleaded guilty to sexual battery. So that is what brought the end to this case as far as the harassment is concerned. In May of 1994, a suit was brought against the school board of Monroe County and the principal Query and the superintendent Charles Dumas. This was brought in the United States District Court, the Middle District of Georgia. The complaint is this: the school receives federal education funding, and because of that, they must comply with Title IX. So their complaint is this, and I quote, "The persistent sexual advances and harassment by the student GF upon LaShonda interfered with her ability to attend school and perform her studies and activities, and that the deliberate indifference by defendants to the unwelcome sexual advances of a student upon LaShonda created an intimidating, hostile, offensive, and abusive school environment in violation of Title IX. The district court did a couple of things. First of all, they dismissed any complaints against any individual defendants, basically saying that since this is Title IX, you can bring a complaint against the institution of the school, but you cannot blame the individuals because they are not the ones receiving the funding. It is the institution that is receiving the funding. The district court also found that Title IX was not applicable at this point because they were looking at student-on-student harassment and not someone in the institution doing the harassing. So it was dismissed. The petitioner appealed the decision by the district court, and eventually the suit came in front of a panel of the Court of Appeals for the 11th District. And they reversed the decision of the lower district court. The Court of Appeals panel used Title VII as a basis for the reversal of the district court's judgment. If Title VII encompasses claims for damages in a sexually hostile work environment, then Title IX encompasses claims for damages in a sexually hostile educational environment only when those supervising authorities fail to act to stop those over whom they have control. The 11th Circuit then granted a rehearing by the Court of Appeals, and at this time, when the rehearing happened, they affirmed the district court's dismissal of the case based on Title IX. Obviously, this case has nothing to do with sports or athletics, but Title IX is ingrained in athletics as we know it today, and it's important that we are always aware of whether or not we are in compliance with Title IX. And one of the big things that I take away from this case, and I think that most students would agree with me, is that it's important to have training not only for your athletes but also for your adults so that people can spot harassment and understand what to do in cases of harassment so that it doesn't get to the point where people are being damaged and schools are being blamed. And that concludes my class presentation of